Good afternoon, ladies and gentlemen. Compliments of the season to you all, and may 2026 be a year of growth, resilience, and a renewed opportunity for your company and the broader consulting engineering sector. A warm welcome to our members, and thank you for joining us today for the CESA Practice Notes webinar. We appreciate your continued support. The practice note for today's webinar are practice notes 22 and 23, addressing the general conditions of contract 2025 with a focus on contractual completion and claims. What are the CESA practice notes? In short, the CESA practice notes are a practical resource that helps consulting engineers in South Africa operate efficiently, ethically, and in line with industry's best practices. They're designed to improve the overall quality and consistency of work within the profession and to protect both the engineer and their clients. To access the CESA practice notes, please go to our website, www.cesa.co.za. Under the Guidelines tab, you will find the practice notes. This is a service for our members, and as such, it can only be accessed by our member firms. If you are from a member access to the practice notes, please contact Gillian, who will be happy to assist you. You can contact her at Gillian, that's Gillian, at cesa.co.za, and I will place that into the chat during the webinar. A little bit about the history of the CESA practice notes. They began in 1962 as advisory notes, with the name change in 2012 to practice notes. Over the years, they have been updated and added to, where we now have over 100 such notes. The practice notes are categorized into 6 specific areas: that of client and appointments, construction stage services, good business practice, legal responsibility and disputes, professional conduct and development, quality and risk management. And if while reading these practice notes you feel that they may need to be updated due to industry changes, please don't hesitate to email me at Oliver, that's Oliver, at cesa.co.za, and I will have our professional team review the practice note. And just to inform you, we are constantly updating these, but it is nice to just, those that slip through, if you do read them, please send them on and we'll happily look into them. Some house rules before we introduce today's speaker. Please can I request that any questions get posted into the Q&A icon found at the bottom of your screen, and any comments be placed into the chat. I will, however, manage both of these during the Q&A at the end of the presentation. Now, let me take this opportunity to welcome our guest speaker for today's webinar. Our speaker is Norman Milne. Norman Milne has over 45 years of experience in the construction industry with 2 major contracting companies, primarily in heavy civil engineering and earthworks project. He retired from the industry in 2019 and established D&M Claims Consultants, providing both dispute avoidance and dispute resolution services to our construction industry. He is a fellow of the Association of Arbitrators, a past president of the South African Forum of Civil Engineering Contractors, SAFSEC, and an associate member of CESA, serving as the chairman of the CESA Contractual Affairs Committee and lead in producing GCC 2025. As well as a member of the CESA ADR panel, he has served as the chairman of the Construction Adjudication Association of South Africa since 2012. He has a particular interest in why projects go wrong and what initiatives we need to put in place to deliver successful project outcomes. And so without any further ado, let me hand over to Norman to start our webinar this afternoon. Norman, over to you. Thank you.
Yeah, thank you so much, Oliver. Thank you for that kind introduction. Just to say that before we really go into these 2 topics, the one being completion and the second one being claims, just to say that we first started looking at revising GCC 2015 round about 2021. So you can see it's been quite a process. The document went through a number of iterations, and before we were happy with it, we took it to the general and interested public on 2 occasions to get input from people that are in the construction industry and have an interest in these sort of things. And then ultimately, through the CIDB, we had 2 sessions with strategic stakeholders to get their approval. So the process was quite vigorous, and I hope that what we've produced at the end of the day is a document that's fair and reasonable and looks after the interests of both parties, that being the employer and the contractor. So getting on to what we're going to look at today. First of all, we're going to look at really clause 514 onwards, which is the stages of completion of the works under the GCC 2025. And then the second one is we're going to look particularly at clause 10, which deals with claims and disputes. I don't know why my screen is stuck. Oh, there we go. Okay, so basically GCC 2025 deals with 3 stages of completion: practical, completion, and then at the end of the defects liability period, what we call the final approval. So practical completion is covered under clause 514.1. And here you'll see that the requirements for practical completion should be recorded in the contract data. And that's quite important because, I mean, practical completion can be quite a nebulous thing, and there could be arguments about what practical completion means and what it doesn't. So the best thing to do is spell it out clearly in the contract data. And then what happens when the contractor considers the work's about to reach practical completion, he'll issue a written request to the engineer for the issue of a practical completion certificate. So he doesn't have to wait till the works are practically complete before requesting it, but he should know that, okay, I'm going to complete it in a week or 2 or the next week or whenever it is. Within 14 days of receiving the request, the employer's agent issues the contractor with a list of items to be completed to achieve practical completion. All right, so the employer's agent's got 14 days to inspect and decide if the works are practically complete, or to provide a list of items to be completed in order to achieve practical completion. If he fails to issue the list within 14 days, then practical completion is deemed to be achieved on the due practical completion date. That's the contractual or the extended contractual practical completion date. Or if penalties are applicable at the time, then on expiry of that 14-day period. And then once the work detailed on the list is complete and accepted, the employer's agent issues a practical completion certificate to the contractor and the employer, and includes a list of items to be completed and defects to be remedied in order to achieve completion. Okay. So, as I said to you, sometimes the requirements for practical completion are not spelled out clearly in the contract data. And then we've really got to look at what's the sort of accepted definition of practical completion. And if we look at those key characteristics, it says substantial completion of the works. The project is essentially finished with only trivial defects. It's fit for its intended use safely and effectively. There's usually a certificate of practical completion that will be issued, and minor defects are allowed. Small issues that do not materially affect use can be rectified later for completion or during the defects liability period. So the works do not have to be 100% complete in order for the employer's agent to issue his certificate of practical completion. So what are the consequences of practical completion? Clause 514.3. So the works are considered complete and penalties cease to be applied or cease to be applicable. An important new thing we've identified here is previously the contractor's obligation to insure only ended at completion. GCC 2025 says his obligation to insure now ends when the works are certified as practically complete, unless otherwise stated in the contract data. The reason for that is practical completion allows the employer occupation of the works. It would be unfair for the contractor to have to continue to insure the works when the employer is occupying the works and actually he's got care and control of the works. The employer is entitled to occupy the works certified as practically complete. There could be some works that are still underway if we've got sectional completion. The contractor must be given reasonable access to complete the works and remedy defects. And where the employer elects to occupy the works before the due practical completion date, then the date of such occupation shall be deemed to be the due practical completion date unless specified in the contract. There could be certain reasons for the employer to having to occupy part of the works prior to practical completion for installing machinery, equipment, or whatever it is. In that case, it will be spelled out in the contract. And where the works are carried out in sections with different due practical completion dates, the provisions of clause 514 apply with the appropriate adjustments. So completion, clause 514.6. So as soon as the works on the list for completion, including the rectification of defects, is completed and accepted, the employer's agent delivers a certificate of completion to the employer and the contractor. Some work or rectification of defects and or clearing site may be left to be carried out by a later date, that date being stated in the certificate of completion. And failure by the contractor to complete by that date may extend the defects liability period by the amount of additional time the contractor requires to complete the whole of the works. So the consequences of completion is that original performance guarantee is returned to the contractor. In GCC 2015, it was said to be returned to the guarantor, which is really just not practical at all. It's returned within 14 days. The defects liability period starts. Retention is reduced by half where applicable. Possession of the site reverts to the employer. The contractor clears the site and makes good before leaving. And where the works are carried out in sections with different completion dates, the provisions of this clause apply with appropriate adjustments. Approval is clause 516. Only the final approval certificate constitutes acceptance of the works. The final approval certificate is issued as soon as practicable after 1, completion of the whole of the works, or 2, expiry of the defects notification period, or 3, after completion of works instructed during the defects notification period. So it's the later of those dates. The final approval certificate, however, is not a condition precedent to the release of the remainder of retention. If final approval has not been achieved, the employer is entitled to withhold payment of so much of the retention money as represents the cost of the work still to be completed. And last but not least, the contractor's liability for latent defects is stated in the contract data. The period to which the contractor is liable is stated in the contract data. So a couple of takeaways. So GCC 2025 envisages one practical completion list and one completion list, and not numerous iterations as often happens on site. So if the contractor does not achieve practical completion, the employer will give him one list to complete. The contractor's obligation to ensure ends at practical completion. In GCC 2015, that was completion. And the performance bond is returned to the contractor, not the guarantor. So those really are three takeaways coming out of completion. So clause 10, claims and disputes under GCC 2025. So if we look at the role and authority of the employer's agent, he's not a party to the contract. He acts as the employer's agent, normally under a professional services agreement. And because he's an agent of the employer is vicariously liable for the actions of his agent. He's given the authority as detailed in the contract. And if the employer wishes to reserve some of this authority for himself, this must be clearly set out in the contract data. However, the GCC working group advises against this. The engineer should be given the authority, the full authority that's given to him under the contract. Once you start restricting this authority, you can run into all sorts of problems. He doesn't have the power to amend or alter the contract. He can't. He's not a party to it. He wears two hats, clearly. In terms of cost, quality, and time, he administers the contract as an agent of the employer. He's looking after the employer's best interests. However, when it comes to disagreements and disputes, he's expected to act fairly and in an impartial manner, taking all relevant facts and circumstances into account. So he can delegate parts of his authority to his representatives, the RD and other people like that. He cannot delegate those following clauses: advance warning, approval of subcontractors, extension of time, completion approval, termination by employer, contractors' claims, and dissatisfactions claims. Those he must deal with himself. Okay, so if we look at claims, clause 10.1.1, 10.1.1.2, and 10.1.1.3. So in GCC 2025, in 2015, the contractor had to submit a fully detailed claim within 28 days. In GCC 2025, we reverted to the more common practice. So the contractor must first give a notice of intention to claim within 28 days after the event, circumstance, act, or remission given rise to the claim has occurred. Okay, and that notice must refer to this clause, 10.1.1.1, must set out the particulars of the event, circumstance, act, or remission, and it must provide the provision or the provisions of the contract on which the claim is based. So those are the three things that must be included in the contractor's notice of intention to claim. Then the fully detailed claim must be submitted within a further 28 days or such other period as may be agreed, clause 10.1.1.2, and that fully detailed claim clearly will include how any extension of time and or additional costs were calculated and all the necessary facts and evidence that support the contractor's claim. If the contractor cannot comply with the time period, the 28 days to submit a fully detailed claim, and no extended period is agreed between the parties, then he must comply with as many of the requirements as he can. Okay, so he must see what he can comply with in terms of 10.1.1.2. If the event or circumstance is ongoing, he must provide updated particulars each month and submit his final claim within 28 days of the event or circumstance ending. If he does not comply with the 28-day notice provision because he is not or could not reasonably be aware of the event or circumstance, the 28-day period shall commence to run from the date when the contractor should reasonably have become so aware. You know, there could be instances where the contractor, in excavations, he starts encountering rock, but he doesn't really understand that this rock may lead to a claim. So it's only after a certain period that he understands, well, wait a minute, this is a lot more rock than I thought it would be. I'm going to require additional costs or extension of time on both. And then he provides his notice. Now that's when the 28-day period shall commence, when he should reasonably have become aware of the problem with the rock and not necessarily when he gave his notice. Any additional cost or time incurred prior to giving such notice covered by existing rates and prices. Okay. Clause 10.1.3 says the contractor keeps contemporary records of all relevant facts and circumstances. The employer's agent may record additional facts. The employer's agent and the contractor shall set out, signed by each party, their agreement or disagreement with the matters recorded. And if it comes to a dispute, the contractor and the employer's agent are not limited to only those facts and circumstances recorded as above. They're entitled to introduce additional facts or circumstances relevant to the dispute. So clause 10.1.4 says failure to comply with the 28-day time periods for extension of time, no additional payment. So no additional payment is done if you fail to comply. Subject to clause 10.1.2. Okay, but if the employer's agent now considers the contractor has failed to give his notice within 28 days, he provides written notice of the failure with reasons within 7 days. Okay. No response from the employer's agent. If he doesn't respond within those 7 days, then it's regarded as the notice is valid. However, regardless if the employer's agent responds or not, the employer can still dispute the fact that the notice was given within the 28-day time period. Okay, the employer's agent. The employer delivers a written and adequately reasoned ruling on the contractor's detailed claim within 28 days of receipt, giving effect to clause 3.2.2, and we'll have a look at 3.2.2 in a minute. This time period can be extended by agreement, but clearly it must be extended prior to the period expiring. He can make a partial award before ruling on the whole claim. So if the employer's agent is satisfied with some of the details that the contractor has given him and believes, yes, he's entitled to a part extension of time or part payment of costs, then he can make a partial award. If he does not deliver his ruling within the time period, then the claim is deemed rejected. This was missing in GCC 2015. So we really had a lacuna where, the employer, if he didn't deliver his ruling within the time period, it sort of hung in limbo while the parties tried to resolve when he could deliver his ruling. Now it's deemed rejected. So clause 322 says wherever the contract requires that this clause should be applicable, or the employer's agent intends in terms of the contract to exercise any discretion or make or issue any ruling, contract interpretation, or price determination, the employer's agent shall, acting impartially, first consult and notice the words, preferably jointly, with the contractor and the employer in an attempt to reach agreement. If agreement is reached, such agreement shall be signed by the contractor and the employer. Failing agreement, the employer's agent shall make a decision in accordance with the contract, taking into account all relevant facts and circumstances. So again, we're probably adopting a similar approach to FIDIC, where we're saying, first of all, let's try and get the parties together and reach an agreement, reach a settlement. FIDIC gives a time period for that. The GCC doesn't necessarily give a time period for that, but it does encourage the parties to sit around the table and try and resolve this without it formalizing into the employer's agent having to give a ruling and possibly that ruling being disputed, etc., etc., etc. So first prize is that we can sit around the table and resolve this amongst ourselves. So the employer's clause 10.2 is a dissatisfaction claim. Now, dissatisfaction claim deals with anything else except the matters under clause 10.1. So dissatisfaction claim can be about the employer reducing the contractor certificate. It can be a decision, a notice that the employer's agent is given, etc., etc., etc. So the employer and the contractor may issue a dissatisfaction claim to the employer's agent on any matters arising out of or in conjunction with the contract, other than the matters dealt with under clause 10.1. The claim must include supporting particulars and relevant facts. The claim must be delivered within 28 days after the act or omission which led to the dissatisfaction occurred, and the employer's agent delivers a reasoned ruling within 28 days of receipt. It can be extended, that time period, before the expiry of the period, and again, failure to provide a ruling within the required period is deemed rejection. 10.3 deals with dispute notices. The employer and the contractor may deliver to each other a dispute notice on any dispute arising out or in connection with the contract. So that's really arising out of clause 10.1 or 10.2. A copy of the notice is given to the employer's agent. The dispute must arise from a ruling, failure to give a ruling by the employer's agent. The dispute notice must state the nature of the dispute and the redress claimed, in other words, the relief claimed. It must be submitted within 28 days of the event giving rise to the dispute. It's referred to adjudication unless amicable settlement is first agreed on, and the parties must comply with the employer's agent's ruling until overturned in amicable settlement, adjudication, arbitration, or litigation. So if one party is given a dispute notice with regard to an employer's agent's ruling, he must still comply with that ruling until it's overturned in a higher forum or a different forum. Clause 10.4, amicable settlement. The parties may at any time propose amicable settlement. If the proposed proceedings fail to commence within 14 days, the proposal is taken as rejected. The amicable settlement process suspends commencement of adjudication proceedings, and agreement in whole or in part of the dispute becomes final and binding on the parties. And you'll notice now that the High Court in the Southern High Court in Gauteng in Johannesburg has now introduced mediation, which is sort of amicable settlement, as a procedure before in civil matters before going to court, simply because to get a date in court is going to take you probably 4 or 5 years, and no one can wait that long for justice to be given. So now parties must enter a mediation process. It's compulsory, it's mandatory. And we'd like to think that the parties will also, when a dispute arises, will look at adopting amicable settlement, bringing in a third-party facilitator, or some other method of settling this dispute amicably before embarking on the formal dispute resolution process. Clause 10.5 adjudication. So GCC 2025 provides for both a standing adjudication board and an ad hoc adjudication board. The standing adjudication board is appointed within 56 days of the commencement date. If the parties fail to do so, then the fallback position becomes an ad hoc adjudication. That was missing in GCC 2015, and there was a court case in that effect which decided that the parties couldn't go to adjudication and had to proceed to arbitration. Under ad hoc adjudication, the adjudicator is appointed by agreement of the parties, failing this by the president of CESA. The adjudication board is either one or three members stated in the contract data. If the contract data is silent, then it's one member. The parties must implement the adjudication board's decision within 28 days of publication of the decision, and the parties cannot refer the dispute to arbitration or litigation unless it has given effect to the adjudication board's decision. So that's something new that's also been introduced into into GCC 2025. So I thought we have a little bit of time, so I thought we could discuss sort of best practice on dealing with claims. I mean, claims on construction contracts are part and parcel of the construction industry. I mean, that's why we have such specific contracts and clauses that deal with claims, and that's why I have a tiered dispute resolution process, simply because there's very few contracts, very few jobs that will not have claims at the end of the day. And claims is not something we should look at, as a dirty word, as something to be avoided. It's something that is, as I said to you, is part and parcel of the construction industry. So what are some of the best practice that we need to consider? Well, we should, at the outset, agree what type of records must be kept in the event of a claim. Right at the very beginning, before a claim has even arisen, say, okay, guys, in the event of an extension of time, let's agree that we want these following records. In the event of proven additional cost, we want the following records, and agree them at the outset. Agree at the outset how the program will be impacted when motivating extension of time claims. Okay, what program are we going to use? How are we going to impact it to prove that the contractor is entitled to an extension of time? Deal with the claim as and when it arises. Don't wait to the end to see if there's money left over in the budget. A claim for an extension of time is evaluated and awarded at the time the impact happened. Sorry, a double happened there. How will the P&G be calculated in the event of an extension of time? Claims happen. Don't take it personally. I mean, as I said to you, it's part and parcel. So just to give you some idea of why I'm saying that, decide how the P&G will be dealt with. So here we have, on a typical contract, if we've got a 12-month contract, and we've got 12 million rands time-related P&G, the contractor will normally recover R1 million a month over those 12 months, so he gets his P&G paid out on that basis. However, he actually expends his P&G on the bell curve shape. He starts off with slow, builds up, mobilizes his site. At peak, he has his maximum resources on site, and clearly as the work starts to finish, his resources tail off, etc., and then he's back to there again. So if a delay event occurs here, where we've got this blue arrow, you can see he's actually under recovering on his P&G. Now, people must say, well, okay, but that space there and that space there actually fills up that area there. So on a swings and sort of roundabout basis, if we pay him his time-related P&G on the straight line basis, then he's compensated for extensions of time. But perhaps a better thing to do is to ask the contractor to give you his actual P&G expenditure, which would follow that bell curve shape. And in that way, then, if a claim occurs here, clearly then he's not going to be overcompensated. And if a claim occurs here, he's not going to be undercompensated. So that's one of the things you really have to look at when you're thinking about how am I going to adjust his P&G in the event of an extension of time. And as I tell you, the extension of time and the event is dealt with as and when it arises, and not somewhere further down the line that simply extends the straight line further on into month 13 or month 14. So ultimately, we can sort of look at there's basically three types of claims. There's prolongation, which let's call it extension of time. There's disruption, which does not necessarily impact the time for completion of the works, but certainly impacts the contractor's ability to carry out the works. And then there's also you can have acceleration claims. So in terms of prolongation, which what we're talking about here is an extension of time. So the basic element that needs to be in place to prove delay is a construction program. That's critical. And what you need is the baseline, let's call it the tender program, but the baseline might very well not be the tender program. The tender program might be a sort of a simpler bar chart that's submitted at time of tender so that the employer and the employer's agent can get an understanding of how the contractor intends to carry out the works. And the baseline program would be the program that's submitted shortly after contract award and prior to the contractor establishing on site. And there should be resource histograms. Clearly, you want to know how the contractor's resources are going to be spread over the duration of the contract. The program should be updated on a regular basis. Weekly is probably a bit over the top, but certainly I would say monthly. The program should be updated monthly, and whenever something changes, there's an extension of time claim or something like that. And I think it's important to simplify and distill the program wherever possible. I think one of the big errors we make in the civil engineering industry is when we submit our baseline program and the scope of work hasn't been fully defined, we still try and program the works and the activities into the nth level of detail, which I think is almost impossible to do. If I take you back to those two power stations that Eskom built at Medupi and Kusile, I certainly know that at Medupi, it was only probably 5 years into the project was the first time that the employer or the employer's agent was actually able to put an integrated program together to get all the various disciplines onto one program to understand what was happening. So, at the outset, at Medupi and Kusile, the scope of work was not defined, and the bill of quantities was based on a different power station, and yet the contractors were expected to program these jobs into the nth level of detail. My advice would be program the first 6 months in detail, maybe program the next 6 months in less detail, and program if the job's longer than 12 months, then just have some bars that represent the time period going after that, and then update it as you go along. And then when it comes to actually proving extensions of time, simplify, distill the program where possible. If there's one critical path, that's quite easy. But if there's multiple critical paths, that becomes quite difficult. And a program with many, many activities can sometimes just be throw every party off. So there's various delay analysis methodologies that can be used to prove an entitlement to an extension of time. And I'd just like to take you through a couple of them. So the first one we talk about is as planned impacted. Okay, so this is really our baseline program, and then we impact it with what the delays that have happened. So it's quick to produce. Depending on the complexity of the program, it's easy to understand. It demonstrates criticality on the original plan sequence. It certainly does. It demonstrates causation. It doesn't rely on as-built information, but really it's useful as a litmus test prior to further detailed analysis. Because the as-planned program rarely reflects what actually happened. We know that. The analysis is hypothetical and prospective because we're looking forward. It does not consider progress at the time or concurrency being where there's both an employer delay and a contractor delay. The baseline program itself may contain errors, and it often does, particularly, as I say, if you're trying to program in too much detail with not enough information. And if you ever go to court, it has almost no judicial support. And certainly in the UK, in the technology and construction court, if you used an as-planned impacted program as the basis to pursue your claim, you'd probably be thrown out. So the next one is as planned versus as built. So it's quick to produce in its simplest form. It requires minimal program updates because all you're comparing is your as planned, your baseline, versus your as built, what actually happened. It's easy to understand if the project is simple with few delays. And the analysis can be broken down into windows or time slices for clarity. So you don't have to just deal with this huge extension at the end. You can look at how this actually happened along the way in certain windows or time slices. The baseline and the as-built programs must be similar. Okay, it fails to consider concurrency again. If there's an employer delay and a contractor delay, it doesn't really consider that. The as-built program is rarely dynamic with historical critical path. It only records the start and finish dates of the various activities. The causation is generally inferred, not proven. And maybe you can prove it with these windows of time slices. And there's some judicial support, as I say, when you get down to these windows and time slice analyses. Okay, time impact analysis. This is quite a common methodology of proving an entitlement to an extension of time. So it demonstrates causation at the time of delay. It's used to demonstrate causation during the project. It relies on established facts. It's the best method of analysis during the project. It satisfies the chain of causation. We said that allows for changes to logic, durations, critical path, and progress and concurrency are taken into account. So how does the time impact analysis work? Well, you update your program to just before the event, occurrence, or the cause happened. So there you've got an updated program, and then you impact that updated program with the delay, the actual cause and the delay, and see what the outcome is on the activity still to happen. So what does it talk about it? It says it can be costly and slow to produce, especially if you're impacting the baseline retrospectively. So this is why it's important to have regular, at least monthly updates on the program. If you're going to take the baseline and impact it with all the events that cause delay, you're really going to run into problems. It requires good supporting contemporaneous records. In other words, records produced at the time of the delay and not long afterwards. Being a prospective analysis, it may not demonstrate the precise actual delay to completion. But I mean, nothing is 100% certain. Because you're looking forward, you're saying, okay, this is the impact it's having on the activity still to happen. It may not demonstrate the precise actual delay. There's good judicial support for this methodology, but it needs regular updated programs to make it work. Okay, the as-built but-for, it analyzes the effect of delay on actual completion. It relies on verifiable as-built data. Each delay is clearly identified in descending chronological order. So you take the last delay in the program and then you work backwards in descending chronological order to the first delay. It's excellent for proving prolongation costs because each period of delay is known, but typically only actual costs or damages can be claimed. So it requires concise and documented as-built logic. It may require several iterations to demonstrate to the employer and contractor the delay events. Looking backwards can be confusing, of course, because you're taking things off the program as you go backwards. And it's difficult to produce, especially if a running as-built program has not been maintained. So it can be used, but it's not ideal. I think the time impact analysis is probably a commonly used methodology of proving delay. Disruption, we spoke a little about it. It's not necessarily delay. It may cause delay or be caused by delay. So what disruption is unproductive working loss of productivity as a result of an employer delay event. It's usually not detected until after it has occurred, and that's one of the problems. It may be masked by other project issues, acceleration, unrecorded variations, mistakes, inefficient working. And so all those things mask the fact that the contractor is being disrupted. And the principles which apply to global claims apply here. And we'll look at that in a bit more detail when we look at how you actually evaluate disruption. But in South Africa, the South African courts do not approve of global claims. You can't just throw everything into one basket and say, okay, this is my total delay, these are my total costs, this is how much I want to be paid. Global claims are frowned upon. So disruption, we said, is not delay, but it may cause delay and it may be caused by delay. So how not to calculate and claim disruption? So that's the first one, is what we call the quantum merit. So that simply says the contractor claims his actual cost plus overheads. He says, okay, I was disrupted. It cost me $1 million plus my overheads. That's the money I want to be paid. I mean, that's really is a global claim, and it won't be looked at favorably at all. So many quantum merit. So all he does is then he says, okay, I want these sections of the works paid at actual costs, and he deducts the original allowance he had for those works in the bill of quantities. The second one is estimated. The third one is estimated resources and outputs versus actual resources and outputs. So he says, okay, this is how much I estimated would cost me. This is how much it actually cost me. Therefore, disruption is the difference. Or a percentage is added on for greater difficulty. He says, well, I was disrupted and the disruption cost me 20%. So therefore, I'm going to add 20% on my costs. And that's my claim for disruption. So these are not how to calculate disruption claims. These will not be successful at all. So the first approved methodology is the measured mile approach. So what is the measured mile approach? It says, well, it compares identical activities on an impacted and unimpacted section of the project to prove the loss of productivity as a result of the impact. Okay, so the first thing it does away with any argument around the estimated outputs. So we're no longer looking at what the estimator decided the outputs were being. We're saying, well, on this undisrupted section, you achieved 200 meters a day. On this disrupted section, you're only achieving 150 meters a day. Therefore, the 50 meters is your disruption factor. It works well on linear repetitive type projects, pipelines, roads, and the like, where you have this almost production line basis, and it's quite easy then to compare on a daily basis where you are disrupted and where you're not disrupted. It requires a sufficient continuous period of productive working to be of probative value. I mean, you can't take a day or 2 days and say, well, I was disrupted, I was undisrupted for these 2 days, or I was disrupted for these 2 days. So it has to be a reasonable period that can be taken as satisfactory. And if the worst comes to the worst, if you have a historical measured mile on another similar project, you could be able to introduce that as your measured mile approach. So that's one way of proving disruption. A second methodology is to use industry standards method. Now, unfortunately, we don't have these in South Africa. But, you know, in places like particularly the US and in the UK as well, they have reams and reams of productivity rates which are accepted and recognized in the construction industry as possible to achieve with productivity actually achieved during the period of disruption. So you have all these industry standards for productivity versus the productivity you actually achieve during the period of disruption. And that then becomes the measured mile. The industry standard becomes the measured mile. And as I say, in the UK, in the USA, in various other places, they have reams and reams of these productivity rates. A third methodology, how to calculate and claim disruption, could be comparison with similar projects method, almost like that historical measured mile we looked at previously. Comparison of the anticipated productivity rates with the actual productivity rates. The anticipated productivity rates must be supported by reference to the productivity rates achieved on the same or a similar project. Okay, so here we're looking at, okay, I achieved this productivity on a similar project or the same project, and now I'm experiencing this productivity. Therefore, again, that's how I'm measuring the disruption. Total labor approach, we looked at it earlier. Decreased productivity is calculated by subtracting the estimated labor cost from the actual labor cost. Not recommended. No attempt is made to segregate the factors that may have impacted productivity. the entire impact is attributed to the employer. So in other words, the entire disruption is attributed to the employer, and it's not a favored approach. You're not going to get away with that. Then there's a modified total cost calculation. So again, it's sort of the previous thing we just looked at, but here now the total costs are modified to remove some of the inherent inaccuracies found in cost calculations. The costs are segregated, impacted work activities versus non-impacted activities. It can be supported by expert opinion on the validity of the original estimate, and it's given more credibility if costs attributable to the contractor's own performance are removed. So what we're trying to do is narrow it down that only those costs associated with disruption caused by the employer are claimable. And here, Mr. Employer's agent or Mr. Adjudicator, Mr. Arbitrator, you can see where I've taken out all these other costs that are really my responsibility.
Norman, thank you very much. Greatly appreciated, and I'm amazed you got through those slides much quicker than I thought. So really well done on your side. Thank you so much for the presentation, and I see we've certainly got a couple of questions that are coming in, and guys, please feel free to continue to load up your questions onto the Q&A, and we'll deal with it from there. Based on EOT, is the contractor obligated to present a delay analysis other than compiled information from a programming point of view? I hope I've read that correctly.
Yes. Look, I mean, clearly the onus is on the contractor to prove his entitlement to an extension of time, and
Okay.
which methodology he uses to prove that. But clearly there's a couple of things. It has to impact the critical path. If it doesn't impact the critical path, then he's not entitled to an extension of time. It must be due to an event that entitles him to an extension of time. And the best way to do that is to impact the program, certainly.
Do we deem standing time as a disruption with GCC as well?
Standing time would not really be disruption. Disruption is where, as I say, you're working in an entirely unproductive manner. To give you an example, in my previous career when I was working for Basil Reed, we built a pipeline for the Department of Water and Sanitation. And the pipeline, we started on two fronts. And the one front was disrupted due to access problems, and the other front was not disrupted. So we were quite able to show that on the undisrupted front, this was the productivity we achieved on a daily basis. And on the disrupted front, this was the productivity we achieved on a daily basis. So that became our measured mile, and then it was quite easy to prove our entitlement to additional costs, not necessarily additional time. Standing time is something completely different. Standing time is where the contractor cannot work because he doesn't have access, or the works have been stopped, or whatever else it is. So standing time, standing time may be one of the things that come out of disruption, but it's by itself, standing time is not disruption.
We are on this topic of claims. All right. Which category or term would a suspension of construction work instructed by employer due to financial constraints best describe this?
Wow. So the employer suspends the works. Well, that's an automatic claim under GCC 2015 and 2025. So the employer suspends, so the contractor is instructed to suspend the works because the employer doesn't have the necessary funds. And so the contractor, if the employer then let's say the employer suspends the works for a month, and then he does get the funds and he instructs the contractor to start up again, the contractor then clearly will be entitled to claim under clause 10. He'll be entitled to claim for whatever costs he incurred while those works were suspended. Clearly, he has an obligation to try and mitigate those costs.
Yeah.
But he could certainly claim for the costs he incurred while those works were suspended, and he would be entitled to an extension of time and additional P's and G's once the work started up again.
Okay.
That's it.
All right, thank you.
that's if the reason is lack of funding. Clearly, if the work is
Yeah.
suspended through some default on the part of the contractor, that's an entirely different story.
You mentioned that the contractor's obligation to ensure ends at practical completion. Surely this should only happen at completion, as risk will still present themselves while the contractor is attending to the list to reach completion.
Um, normal contract or risk insurance policies normally covers the works damage lost to the works until the works are taken over, and then any damage or loss caused by the contractor during the defects liability period. So if the contractor is rectifying some sort of defect during the defects liability period and he causes damage to the works, the contracts or risks policy will cover that. But understand, on practical completion, the employer takes occupation of the works. So again, to ask the contractor to carry on insuring the works when he actually has no control over those works, because now the employer's taken occupation until the issue of the completion certificate, is a risk that is unfair for the contractor to take.
Is the GCC 2025 ready for implementation, or by when and when do we need to move from 2015 to 2025?
That decision is entirely up to you. I think that you should migrate, and you should start preparing your tender documentation, all those things based on GCC 2025. But that's entirely up to you. I mean, at CESA, we still get requests for GCC 2010, someone wanting a copy of GCC 2010. We're saying, guys, you shouldn't use it. I mean, the CIDB and the standard of uniformity will say you must use the latest version.
Yeah.
And the CIDB, when they publish the new standard of uniformity, which is going to happen hopefully this year still, they will emphasize that GCC 2025 is the recommended contract to be used. It's not mandatory. It's not law that you have to use it, but they will recommend that that's the contract the version of the GCC you should use.
Right. You showed a bell curve for time-related P's and G's.
Yeah.
Can one insert a request for this to be provided in the contract data?
Yes. You can certainly ask the contractor to give you his actual P&G expenditure on a monthly basis. Absolutely. And as I say, that's probably a better way of then, when you have an extension of time claim, or you have, then it's a far better way of assessing what the contractor's actual costs are and reimbursing based on his sort of actual costs and not his theoretical costs. In FIDIC, in the FIDIC document, an extension of time claim, they don't base it on the monthly P&G. They speak about actual costs. So it's costs incurred or to be incurred. And that's how the contractor gets reimbursed under FIDIC. So they don't use the time-related P's and G's. They use the actual costs that the contractor incurred at that time when the delay happened. And I think that by showing that bell curve, we're trying to, as GCC 2025, we're trying to illustrate a similar thing.
Another one, this is quite a good one. We, the employer, enlist the use of local labor in a project. Will it be deemed disruptive if the local labor are not willing to accept a labor rate but want BCCEI rates?
That's a good question, yeah. So you're the employer and you want the locals to be used.
Yes, so obviously locals are on the project.
Yes.
And they've obviously not happy with labor rate, and now they want the BCCEI rate.
Yeah. Well, on lots of contracts, there's these what we call these expanded public works programs. So some of the contracts will have a part of that contract will be done under the expanded public works program, and in those circumstances, the rates that you pay are prescribed, either on an hourly basis or a task-based basis or something like that. So, I mean, those rates are prescribed. So if the workforce should then go on strike because they're saying, no, now we want to be paid the BCCI rates, which is significantly higher than the expanded public works program rates, and then the contractor would have a claim. It wouldn't be seen as disruption. It would be seen as a claim under the employer's risks, which talks about disruption on site, strike, commotion, disruption on site, those sort of things.
Okay. All right. Thank you. Thank you.
The good thing to do is
Big,
to sort out all those up front. Make sure that all those things are sorted out front before the contractor even sets foot on site. And
yeah.
Sanral on their projects nowadays, for the first 3 months of the project, they have a sort of a period, they call it a mobilization period, where they sort out all these little idiosyncrasies or these little things that can cause great problems later on. And I think that's been proven quite successful as far as Sanral is concerned.
Okay. Great. I think the biggest problem is that there's, once something has been signed
Yeah.
and something better comes along, the understanding is that what was signed falls away and they
Yeah.
can kind of go with that. And I think that's obviously one of the biggest problems on sites is that they always look for the better outcome for themselves.
Absolutely.
Can there still be outstanding defects when the final completion certificate is issued, or should everything be done, delivered, as built, done, etc.?
Okay. So you were talking about now about the final approval certificate. So the final
Yes.
approval certificate is acceptance of the works. So that says that I'm issuing the final approval. I'm happy with the works. They're 100% completed in accordance with the contract. So I would suggest that if there's still defects outstanding, I mean, it's entirely up to the employer or probably up to the employer because the employer's agent cannot modify the contract. It's up to the employer to say, yeah, okay, you can issue the final approval certificate provided the contractor undertakes to fix X, Y, and Z in the following month or something like that. That perhaps the contractor can't get access to rectify those small defects, and the employer says you can only come in a month's time, in which case it might be, advantageous to give him his final approval certificate, as long as you get his commitment to come back and fix this
Yeah.
little bits and pieces. But the final approval certificate signifies total acceptance of the works. So it's a big thing to issue the final approval certificate.
Yeah. Can you please explain the impartiality of the employer's agent in GCC 2025 with respects to claims?
Yes, okay, yeah. This is always a difficult one. And I mean, it's something that I've experienced in the construction industry for years and years and years. Because as we said, the employer's agent wears two hats. When it comes to cost, quality, time, he's there to look after the employer's interests. He's not there to be fair to the contract and say, okay, there's only small honey coming there. I'll let you off with it. Anything like that. He's there to insist that there's no honey coming and those sort of things. But when it comes to claims, then he's supposed to take off his employer's hat and put on his impartial hat. And impartial, we're saying that he must look at it, and he must look at all the facts, all the circumstances. Then he must make a ruling that's fair and reasonable, and that ruling must be it must be motivated. So he can't just say yes, okay, I'm disputing your claim because the employer disputed it. His ruling, he must give reasons behind his ruling, and at the end of the day, he's supposed to act in that impartial manner. And sometimes it's difficult. I know, because I mean, let's face it, that the employer pays the employer's agent. It's not the contractor that pays the employer's agent, and the employer is the one that's probably going to give the employer's agent repeat business in the future. But still, he's expected to, and the courts will insist that he acts in that impartial manner. When he acts in terms of clause 3.2.2 and gives a ruling or a decision. I hope that explains it.
Is there a comparison document between changes from 2015 to 2025?
Yes. We actually sent that out. I'm trying to think. We sent that out in 2024. I think we sent that out to the industry to show the changes. Yes, there is a comparison document. Yeah.
Can you revise 2015 GCC to 2025 GCC clause at any stage during a project execution period, or is it preferred to amend these clauses before execution?
Yeah. Okay. Remember that there's two parties to the contract. There's the employer and the contractor. So if during the currency of a project, in other words, the contract's been signed, the project's ongoing, construction's happening, the parties decide that they want to amend some of the conditions that let's say the contract's GCC 2015, and they want to incorporate some of the provisions in GCC 2025, provided they agree to that and introduce it by way of an addendum, they're perfectly allowed to do so. But one party can't do it unilaterally. You must do it in agreement, yeah. But I would suggest that probably the better thing to do is to, if you've started on 2015, to finish on 2015 and start on 2025 and finish on GCC 2025, rather than trying to mingle the two. Once you start pulling in different things, you might very well introduce ambiguity. You might introduce, that you've got conflict in certain clauses and those sort of things. And that's why we encourage everyone to try and amend the GCC 2025 as little as possible, and not to go overboard with a whole lot of particular special clauses, because again, that could very well be in conflict with what's contained in the GCC 2025 itself, and lead to all sorts of disputes and those sort of things.
Yeah, absolutely. In fact, you would argue that any sort of amendments to the GCC 2025 would result in it not being the GCC 2025. It would be an amended contract that nobody really is obliged to kind of deal with. Yeah.
I mean, Oliver,
all right.
FEDIC have got what they call, I think it's the 5 or 6 golden rules. And they say, if you don't follow these 5 or 6 golden rules, we will not endorse this contract as a FEDIC contract.
Yes. 100%. And I think the same applies to what you guys are saying.
Yeah.
What if contractor at tender stage does not indicate varied P&G amounts and just provides equal amounts over the period, i.e., it does not follow the bell curve? Can the employer reject his tender?
Well, that's up to the employer. Yeah, it's entirely up to the employer. I mean, you can say, okay, yeah, that's fine, but I want your detailed P&G breakdown. Or you could just simply say, okay, you've got 12 million rand divided by 12 months for time-related P&G, therefore that's the basis that I'll pay you. So it's entirely up to the employer. So he says he can decide what he wants to do.
Okay.
And I'm sure guided by the employer's agent.
Yeah. There's a follow-up related to labor rates. Should consultants advise public entities such as municipalities to address their policies on local labor rates for projects? The contract is obliged to pay labor BCCEI rates, but this normally causes local economic issues such as local farming laborers resigning and working on the construction projects because of receiving double national minimum wage. After the project is completed, the ex-farmer labor now sits without work.
Yeah. That is a huge problem. Make no mistake. I mean, we're trying to create employment, and I mean, the construction industry is a good vehicle for employing unskilled and semi-skilled people. So, and we're trying to create as much employment as possible, and that's why government had introduced something like the expanded public works program, and all these sorts of things. But the civil engineering industry has the bargaining council. And it's mandatory if you're a construction company to belong to the bargaining council, and you must pay the bargaining council rates. Under the expanded public works program, you can pay lesser rates. And how you actually marry those two, it's very, very difficult. But I think you're quite right. Up front, you need to sit down with the employer and just agree how you're going to deal with this whole thing. Because I think under the expanded public works, when I looked at it last, I think the hourly rate was about 26 Rand a day, or 27 Rand an hour, whereas the minimum wage under the Basic Conditions of Employment Act was something closer to 55 or 56 Rand. So there is a significant difference. And it can lead to problems. What happens then, you get contractors pricing at the cheaper rates or pricing at the more expensive rates and paying at the cheaper rates. And actually all they're doing is enhancing their profitability.
Yeah.
So it does. And I know that the Bargaining Council have tried to address this with the Department of Labour and the Department of Public Works. But, it takes time. Government is like a huge ship. It takes time to get it to turn around or to get it to understand sometimes the problem they're creating for themselves.
Yeah, and I think as you said, it's going from a temporary employment on site while the construction is taking place and forfeiting a kind of like permanent position as a laborer on a farm, and then the
That's right.
consequences of that are lack of employment. So the whole understanding of trying to
Yeah.
improve the unemployment situation is actually made worse come the end of the contract.
Agreed. And I mean, the expanded public works program sets out that items in the bill of quantities should be identified as EPWP items.
Yeah,
Um, but that often is not the case. And the employer just says, well, they're all expanded public works items or something like that. So you need to get all those things settled up front, in place up front.
yes.
There's no argument afterwards.
Yeah, 100%. Planning is the key, hey? The more better
That's
you
right.
plan, the
Yeah.
the better the outcome of the project,
Yeah.
100%.
You know,
All right,
um,
so
sorry, Oliver, just to expand on that a little bit. So the contractors who are part of the bargaining council have to approach the bargaining council where they want to pay less than the rates prescribed by the bargaining council. And this particularly applies to the expanded public works program. So they will submit the tender, the contract, etc., to the bargaining council, and the bargaining council will go through it and either grant them exemption or not a grant them exemption. So it's important that all those things, as you rightly said, are
yes.
sorted out right up front.
Can the GCSC 2018, the general conditions of subcontract, be used with the new GCC 2025?
Yeah. Okay. Um, so let me. So GCC 2018 was specifically drafted um, to fall in line with GCC 2015. So it was drafted a bit later, but it's basically based on GCC 2015. There were numerous errors in that GCC 2018 document. So a number of amendments have been published, and they're on the CESA website. Okay, so that's number one. So we had to amend GCC 2018 to bring it more in line with GCC 2015. As you can see in GCC 25, there are certain, I wouldn't say radical, but certain things that are quite different to GCC 2015. For instance, the fact that you only give notice of a claim within 28 days and no longer submit the fully substantiated claim, and a couple of other things as well. So GCC 2018 will not seamlessly fit under GCC 2025. We are busy working on what we're calling General Conditions of Subcontract 2026. We're ready to start off with it. We're just waiting for CESA to give us the go-ahead. And we're hoping that we can have that document out this year, which then will speak to GCC 2025 and to a greater extent be back-to-back with GCC 2025.
Two, if the contractor does not or forgets to submit or raise an early warning in
Yeah,
time,
yeah.
does his EOT claim with delay analysis stand ground in GCC?
No, 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 no. We don't want to penalize. So what we're saying is it's good project management to all for each party, the employer, the employer's agent, and the contractor to raise an early warning to say this is going to, this might happen. And if it happens, these are the consequences. But we're not going to penalize him if he doesn't issue an early warning. No, he could still have an extension of time claim and all those good issues. It's not like NEC where, the principal agent will say that, you could have issued an early warning, therefore I'm going to evaluate this compensation event as if you had issued an early warning. GCC is not like that. We're just
Okay.
trying to simply introduce good project management practice.
If there is a contractor's claim with a financial implication to the employer slash project as a result of an omission by the employer's agent in the BOQ, spec or drawing, may this cost implication of this be passed on to the agent in terms of the CIDB PSC?
I've seen instances, and I'll be quite frank with you, where employers have gone after the employer's agent's PI, because they're saying, yeah, it was your error, therefore, I have to pay the contractor, and I'm going to come after your PI, which I think is wrong in its entirety. I mean, no one is perfect. The employer approves the document. And hopefully he's got sensible people in his office that are able to scrutinize the document and say, yes, they're happy with it before it goes out to tender and before the construction project is awarded. So, yeah, I mean, I think it's wrong to do that, but I've seen cases of it happening.
So the temporal solution will be to prepare contract documents to address the shortfall in GCSC 2018 to align with GCC
Yeah.
2025. I think
If
that's,
you look, if you're looking for a quick fix, that would be it, yeah.
yeah,
But as I'm saying, there was a whole lot of amendments to the published version of 2018. So there was never a new version of 2018 that incorporated all those amendments. Those amendments
yes,
are like loose leaf inserts into 2018. So it becomes a little bit of an exercise.
yeah.
Yeah.
And I think on top of that, it adds to the thing that quick solutions are not always a
Yes.
good a good solution.
Yeah.
And things get left out, or there's issues that, as you said, with ambiguity and that coming in,
Yeah.
you never know what you might get at the end of the day and the consequences of such a contract. Norman, I do believe we have come to the end of our questions. And so I do thank you for your time. Thank you for your insight. Thank you for making yourself available and for the work that you do on the GCC. And from what I've understood just in the little conversations we've had, your knowledge within the industry and what you're doing. And I think I love the way you kind of finished off your bio in that you have a particular interest in why projects go wrong
Yeah.
and what initiatives we need to put in place to deliver successful project outcomes. And I think that sums up what we're trying to do in these contracts, regardless as
Well,
to what they might be.
yeah. Oliver, I was in the industry for a long time, and my experiences on projects when they go wrong, when the shit hits the fan, it hits everybody equally, whether you're guilty or not.
Absolutely. Yeah,
So we must try
absolutely.
and I mean, as an industry and as a government, we have limited amount of money to spend on procurement, construction, infrastructure, and we must spend it wisely and spend it correctly.
Exactly. No, thank you very much, Norman. Thank you very much. And what a wonderful way to finish off. So colleagues and friends of CESA, at this point, we've reached the end of today's webinar. And I'd like to take this opportunity to thank you once again, to thank Norman for his time and for sharing his knowledge and thoughts with us, as well as to our delegates for supporting CESA and attending our webinar. In closing, I'd like to kindly request delegates to complete the satisfaction survey that will pop up on your screen at the end of this webinar. And delegates, please note that if you are EXA registered, you may claim 0.15 CPD points for attending this webinar as per our webinar attendance list. I have indicated that this webinar will be made available on our CETV YouTube channel. Please just give us a couple of days just to do a little bit of editing to make it run smoothly. And again, thank you for your attendance and participation. Norman, thank you very much. And to everyone else, thank you and goodbye.